New Jersey. I'm the Policy and Advocacy Advisor. We're so thrilled today to have attorney Rupal Parikh back with us to provide an update on the latest issues impacting our community related to immigration. We understand that this is a very difficult time for many of us in our community. And we wanted to have this follow up to provide really some updated information. Information is power, and we want to invite folks to go to our website for more information. We have a lot of content that Rupal will be presenting today. Rupal has over 30 years of experience. She's based in Montclair, and she's going to be providing us with a lot of information. So I think we're going to ask everyone to sort of put your questions in the chat or to wait till the end for the Q&A. Finally, I just want to say that we're providing information today to everyone. This is not legal advice. Everyone has different experiences and circumstances, and we just want to remind everyone to please reach out to an immigration attorney to talk about your own personal or your own family members' circumstances. I'm going to turn it over to RuPaul.
Hi, everyone. Very nice to meet you. So grateful for having this opportunity to, educate the community. I love doing this. So I hope that the presentation today, you can walk away with some information that then you can bring on to people that you know, whether in your communities or in your families. Let me share my screen. Okay, so, in preparing this presentation for today, I did it in collaboration with AAPI, obviously, and, conversation with Jeff about what some of the leading community questions are, along with, addressing what is happening right now in immigration. So that's kind of how this is structured, and let me get started if I can figure out how to move the slide. Hold on just a second. I had it for a second and now I don't. Oh, here we go. Okay. So navigating immigration, this is a Know Your Rights presentation and how we can plan as we move forward through this year. So, immigration has been in the news nonstop. What is happening in the current policy, in what's the current policy environment. So we all know there have been significant policy changes and there has been escalation of enforcement last year into this year, that there are more aggressive deportation operations. People are being detained left and right, American citizens, green card holders, and undocumented folks. There are longer processing times, even with legal immigration, and there are a lot of holds on pending cases that are already filed with immigration now. There have been new travel screening procedures put into place. There are travel bans for over 75 countries, and there are bottlenecks happening at the consular level. So immigration was broken before this administration. It is way beyond broken now. That is where we are. So as I mentioned earlier, those questions that had come in, and we centered this presentation around and here are the few of those questions. So what are the travel considerations for citizens, green card holders, and visa holders alike, right? Normally, a couple of years ago, no one would ever ask me that question: what is a travel consideration for a citizen? Now it's a very important, pertinent question. Next was, what happens if we have run into ICE? What are the interactions? How do we handle that? And should we carry proof of citizenship if we're citizens? What if you're here, you're undocumented, and you're thinking about self-deporting? How do we weigh that out? What are the considerations that need to be put into place before you make that decision. And also, if you are in the process of or have eligibility to apply for a green card, should you do that now? Is this a good time? And then two more questions, one revolving around employment based immigration, which is H-1B issues. I'm sure you guys have all heard about the $100,000 fee and, all the stuff going on, and them, USCIS changing the way the H-1B visa lottery is going to run. So I'm going to talk a little bit about that. What's the latest for this year? And then lastly, what should employers do to protect their vulnerable workers? So I'm going to try to address it with all the new information. So let's get started. And, like Jeff said, if you have any questions, please put them in the chat or save them for later. As I'm doing these slides, I can't see the chat, so I won't be able to address, things as they come in. And I think I'll just try to handle those questions at the very end of the presentation. So section 1, let's talk about travel and documentation for U.S. citizens, right? You are going to need a valid U.S. passport required for reentry. This is not new. If you are traveling outside of the United States, you're going to need your passport and possibly a visa to whatever country you were going to, and you needed to have that passport to re-enter. Everyone hopefully has heard about Real ID. The enforcement for that went into effect May 7th, but it was kind of haphazard, but now it's full into effect. You can get a Real ID through the New Jersey DMV, New York DMV. However, if you don't, you can use your passport card, or a military card, or a trusted traveler ID. If not, you're going to have to pay a $45 fee, I believe it is right now. And you can do that directly through the airlines when you're checking in. But my, big thing is, if you are a U.S. citizen, you do not need to carry your N-400. If you're a naturalized citizen, you don't need to carry your certificate of naturalization with you, but you can carry a copy of that. You can carry a copy of your passport. You don't necessarily need to have a passport, the whole physical thing, because if you're afraid that it would get lost or stolen, then I would say carry a copy with you at all times. This is the times that we're living in, and it's easier to show them your status than to just say I'm a U.S. citizen, in case you have an encounter with ICE and they're questioning, what your legal status is in the country. A lot of people that I've spoken to in my community and my family and friends are ordering passport cards. So it's like a driver's license. You just have it with you. You can use it to travel domestically. And if you are stopped or have an encounter with ICE, you can always show them the card, which seems to be, a really good way to handle this. Now, if you are a green card holder, you can travel with a valid green card and your passport of the country of which you are a citizen. And, people are always calling and asking me, Rupal, is it safe to travel right now? If you're a green card holder and you have been maintaining your status in the United States, meaning you are really living here and you do not have other issues, criminal issues, you've never been arrested, or it's minor infraction, whatever it may be, if there's any sort of touch with the criminal system, I say you speak with an immigration attorney on whether you should travel or not. Not that they would not let you back in, it just might raise the bar on, questioning and how they handle you at the border. We have people who are, 10-year, like have a green card that's good for 10 years, and then we have people who are conditional residents. That means they have a green card that's only good for 2 years. And say their card is expired and they have filed to renew, and they've gotten a receipt from the USCIS which validates their card for a 4-year period. Can they travel with that? Yes, we were telling them, yes, you can. But what I'm seeing on the ground is that people are having some issues with uninformed CBP officers. So, what I always suggest is to go get what's called an added stamp in their passport, an I-551 stamp. And this can be done by making an InfoPass appointment with your local USCIS office. And you bring them proof of your green card, your status, even if it's expired, the I-751 receipt, and they will provide you with a stamp in the passport that validates your green card for a year. Right? So when you come in with your passport, there will be a stamp, you'll have the expired green card, and you'll have the 751 receipt. That should, ease the entry into the United States with very few problems. Can't promise you that there will be no problems, but there will be fewer problems. If you are a green card holder and you take a trip outside of the United States that is longer than 6 months, you are definitely going to be questioned, and there is a risk there that they're going to, and I mean CBP, this administration, are going to claim that you abandoned your residence. And I could speak a lot more on this topic about what you can do to not show, but then we'll just get lost, and we can answer that afterwards if that's a concern. Third country travel. Now, what we've seen on the ground here, we just had a client who, same was a conditional resident, has been traveling all over the United States and outside of the United States with the expired card and the 751 receipt. No stamp in the passport, just those two documents. And she was trying to go to Mexico and was not let on the flight because apparently Mexico does not accept the I-751 receipt as proof of status. So she was turned back and not allowed to go on vacation, even as a green card holder with her family. So, if you are traveling, just make it, as a conditional resident, just what I would urge is, double check with the country that you're traveling to see if they will accept these receipts and the expired green card without the stamp in your passport. If you have the stamp, I don't believe that that's going to be a problem for any country because it's proof of, your legal permanent resident status, and it's usually given for a year. So next, let me see, again, I lost my bar to move these slides. Okay, here we go. Advanced parole applicants, for people who are applying to adjust their status. And what that means is these are folks who are in the United States who are either married to a U.S. citizen or are applying for a green card through employment or through their children. Can they travel? So in order for those folks to travel, they need what's called an advanced parole document. Because when you are in the United States and you've applied for a green card, what you are asking the government to do is you're asking them to change the status that you're currently in, which could be, you could be out of status, you could be a student, you could be an H-1B, whatever it is, whatever current status you have, you're asking the government to change you to a green card status, right? So while that's processing, you're in a middle phase, right? You still have the status of your underlying status, possibly, but you're asking the government to change your status to that of a permanent resident. If you were to travel during that time, then that no longer applies because you can only apply for a change of status when you're physically in the United States. So were you to leave, that whole application would be basically abandoned and denied. So what the government has done is they're issuing these advanced parole documents, which you apply for when you apply for your green card. You need to have that approved prior to your leaving the United States. So if you don't have it and you think, oh, it's going to come in and I'm going to pick it up, or I'm going to have them send it to me, abroad, don't do that, because you do not know when it's going to get approved, if it's going to get approved. And if you leave without it, it abandons your green card application. So if you are using the advanced parole document to re-enter, have your passport with you, have the approval notice and the approval notice of the green card application that you filed. Processing for the advanced parole document is taking several months right now. So we've talked about citizens, we've talked about green card holders, conditional green card holders. Now, what if you're just in the United States and you're a visa holder? F1, H1, J1, whatever your visa status is, right? So how do you re-enter the United States? You need to have your valid passport and you need to have a valid visa stamp for re-entry. So remember, that visa in your passport allowed you to enter the United States in the first place. That visa sometimes has an expiration date on it because it was only issued for the purposes of entry. It does not define what your status is in the United States. Now, so if you were to travel and your visa is expired, you are not going to be able to use that visa to re-enter the United States. So you're going to have to get a new visa. The problem is, in order to get a new visa, and you have to do this overseas, is that there are new vetting rules, there are social media screening for everything, and there are massive backlogs and processing delays because the State Department has been given all kinds of instructions to do. Everyone has to be interviewed. There has to be, serious and robust vetting of the individual. And, heavy use countries, China, India, there's just going to be massive backlogs. So what we're advising our clients, and we look at it on a case-by-case basis. So is not to travel if your visa is expired or to try to set up a visa appointment prior to leaving. So, you can plan properly, because the last thing you want to do is get stuck outside and you can't come back to your job or to your life, right? That would not be fun. So again, if you are an F1, whether you're on F1 or F1 OPT, you need to have a valid F1 visa stamp, and you need to take your I-20 with you, which has been endorsed for travel. And if you're on OPT, you need to take your work authorization card with you as well in order to re-enter. Not to leave, but to re-enter the United States in that status. If you are on an H-1B visa or an L-1 visa, you're going to need a valid H-1B stamp in your passport or a visa. Or an L-1, you need an unexpired approval, and you need an employment letter. And what we usually do for clients is not just an employer letter, but we put together a pretty strong package for the H-1s and the L-1s so they can provide that at the border for them to be let back into the United States. What should everyone carry, no matter what your status is, whether you're on a visa, you have a green card, or you're a U.S. citizen? Carry with you at all times government ID, any copies of immigration documents, and a contact for an attorney. Whether you've made connection with them and said, hey, can you represent me if something happens or not? Make sure you have someone that you can contact or your family can contact if there's an issues. Citizens, again, just to recap: passport, real ID, naturalization certificate copy, LPRs, their green card, and the receipt if conditional, and go and get a stamp. Even if you're not planning on traveling, I would get a I-551 stamp in the passport. Visa holders, obviously carry your passport, your visa, and any approval notices that you may have. So now we're going to get into the Know Your Rights section. And this is interesting because so much has stayed the same from when we first did our Know Your Rights, but so much has changed because it seems that none of those know your rights thing really applied, I mean, from what we saw in Minnesota. But we're going to try to address it to the best of, our ability at this point. So, proof of status and citizenship. It is a legal requirement that if you are a green card holder or a conditional green card holder, you must always carry that green card on you. I know so many people who don't carry it. Now is not the time to do that. Even if you want to carry a copy because you want to leave your card at home, but have it on your person at all times. If you are a non-citizen, not just a green card holder, but someone who's undocumented or in a different status, always carry your immigration documents and some sort of valid ID with you. Again, copies are fine. Citizens are not required ever to carry any proof of citizenship, but now, and with what's going on, I highly, highly recommend that because, it reduces the risk of wrongful detention or any sort of prolonged questioning if we can show them, hey, here's proof of our citizenship, or we hope to anyway. Road travel. Right. So what we know about how CBP operates, they operate checkpoints within 100 miles of any border. And, even as an immigration attorney, right, I'm always thinking of the border as the northern border and the southern border, but we also have borders on both sides of our country and on the sides, right? And this 100 miles includes all of New Jersey and pretty much all major metro areas in the United States. So, that's why we see CBP inside the United States. You do have the right, if you are stopped by Border Patrol, to just stay silent. You can tell them your name. You can ask them, am I free to leave or am I being detained? Now, you can also, in order to not elevate any sort of problem that they might be having in the way they're treating you, whatever, so if you do have your valid ID, I think at this point it's good to give it to them rather than denying that and exasperating the situation. But you're going to have to read it as it is if you are stopped. Unexpected ICE encounters, again, just to, expand on the slide before, you do have the right to remain silent outside of stating your name. You have the right to request an attorney. You have the right to refuse to sign any documents you don't understand. And I can promise you, those documents are not going to be easy to understand, right? So even if you're a U.S. citizen, green card holder, you read, speak, write English perfectly, don't sign anything. You can just say, I don't understand this. I need an attorney to look at it. I'm not signing anything, because the way that the things are written, the way they're being presented, you do not want to lose your rights to anything, right? Even if you think you can understand the plain language of what they're asking you to sign, I would not sign it. But don't ever run, don't resist, and do not present false documents, right? Copy your original documents if you're carrying copies, but never, never, never present false documents, even by accident, because it can cause a lot of big issues down the line. Policies and laws. The Immigrant Trust Directive. So what it does, this was a law that was passed in 2018, or I think it's a policy more than a law. And it was issued by the New Jersey Attorney General. And what it does is it limits the type of voluntary assistance that New Jersey's 36,000 state, county, and local law enforcement officers can provide to federal immigration authorities, right? Including ICE. So police officers cannot participate in any federal immigration raids. They cannot stop. They cannot question. They cannot arrest, search, or detain any individuals based solely on actual or suspected immigration status. And they cannot ask about immigration status except in rare cases when it's relevant to a specific criminal proceeding. Okay, so, you could encounter ICE. That's different, but you're not going to see New Jersey police officers assisting them or taking part of these enforcement actions. And if you do, obviously, you've got to document that because that would be against our policies. And the Safe Communities Act was just signed into law by Governor Phil Murphy in January 2026 before he vacated the office. And what it does, it's to ensure that all community members, right, regardless of their status, feel safe accessing critical services, especially with hospitals, schools, courthouses, and places of worship. So it prevents all of those places from assisting ICE in any sort of way. I mean, I think we had heard stories coming out of Minneapolis about a church pastor who was working for ICE. You can't do that in New Jersey. So, now, what do you do if ICE would come to your home? Don't open the door without a judicial warrant, okay? And a judicial warrant is something that is signed by a judge. You will see it. It is not an ICE administrative warrant. And this is a very tough area for most people to navigate because you're scared. ICE is at your door. You're asking them to show you the warrant, and they're showing you a piece of paper, and they're taking it away. How do you know if it's an administrative warrant or a judicial warrant? My advice is it doesn't matter what they have. Don't open the door. And their administrative warrants do not authorize entry at all, even though they, ICE might want to say it does, but under the law, it does not. You can ask to see the warrant, and the only way they are allowed entry into your home is if a judge has signed that warrant. We got to do the best we can in those situations. So how do we, as a community, document encounters? How do we get help? And what's been happening in Minneapolis has been a great, at least on the community level, it's been a great example to all of us. Write down the names, badge numbers, agencies, date, time, location of any ICE encounter that you witness. Keep attorney contact information accessible. Families should know how to locate their detained members and do not sign anything without speaking to an attorney, right? So this whole thing about families should know how to locate detained members. What we're seeing on the ground is someone gets picked up, they are taken to the nearest detention facility, and then they're moved very, very quickly. I've had, knowledge of clients being moved 10 times within, a week period. And, the families really can't find out where their person is because of what ICE is doing is moving people. But there are ways to find out. So, we will find them at some point in time. But it's good to have an attorney or a local service charitable organization who, is helping with this kind of stuff on your side, right, as a resource to be able to get help to find out where your family member is if they are detained. So next section, status management and self-deportation. So we get a lot of questions of how do I maintain my status in times like this? And what if I am here undocumented and I just want to leave? That's called self-deportation. Should I just pick up and leave the country? So, in order to kind of address those questions, we have to have some fundamental knowledge of what it is that could happen and, how long you've been here in the country. So there's a thing in the law called unlawful presence. And what that means is if you are here in the country, even if you entered legally, say you came in on a visitor's visa, you had 6 months to stay here, and then you didn't leave for whatever reason. But for legal status, you are out of status. Once you become out of status, unlawful presence starts to accrue. It is something that the government counts. How many days have you been here in this country unlawfully or without status? If you are here in the country between 6 months and just one day under a year, 180 to 364 days unlawfully present. That means after your status expires and you leave the country, you cannot re enter the country under any circumstance for 3 years. It's a 3 year bar. Don't even try to apply. Don't try to ask for waivers or whatever. 3 year bar. 10-year bar is goes into place if you are unlawfully present in the United States for 365 days or over, and then you leave. These bars are only triggered when you leave the United States, and just staying here, that does not ever erase your unaccrued or your accrued unlawful presence. Okay, so that's something to have as a base in determining whether or not you should self-deport, because you really need to know that there will be these bars if you were to leave. Some people always ask, if I'm in front of an immigration judge, what is better for me to take a voluntary departure or do I take a removal order? So voluntary departure is when you ask the judge to you leave at your own expense, not at the expense of the government, and you leave within a certain time. If the judge grants it, it's great for you, and it avoids a formal removal order if you meet all the conditions of the voluntary departure order that the judge, has given you. Now, if you take a removal order, that is what a removal order is a formal deportation order, and that will trigger some bars to re-entry. It could be for 5 years, 10 years, 20 years, or it could be a permanent bar depending on how and under, what circumstances the removal order was issued for. Now, now that we have that background, if we're here and we don't have status and we're weighing self-deportation, remember, if you leave, that could, trigger a 3 to 10 year bar if you've accrued unlawful presence. And if you have any applications for waivers, green cards, anything pending with USCIS, that abandons that application. And also with immigration court, if you have something pending with immigration court, it abandons it, which could result in a removal order, which could result in longer bars or a permanent bar. So, if you are in this situation, we highly, highly recommend that you speak with an attorney before you make that decision to self-deport, right? Sometimes, I've had clients who are like, I can't take this anymore. I'm so scared. I'm just going to leave. And we really have to go through their immigration history to decide what's the best for them. People are also asking, do I do an adjustment status, which means applying for a green card in the United States, or do I choose consular processing if my spouse or child is abroad? So an adjustment of status can only be done if your partner, your child, or whoever is in the United States. And it allows the person who's applying to get a work authorization, also an advance parole, which allows them to travel. And currently, right now, it's taking 8 to 14 months of processing, at least here in the Newark field office. I believe it's similar in the New York field offices as well. Everyone is being interviewed. So there was a long period where if the application that was submitted met all of the check boxes that that the immigration officers have to go through, in seeing whether this is a valid case, there were interviews that were waived. That is no longer the policy under this administration. Every single application is being interviewed and thoroughly vetted. So that is what you're going to get if you're, going to apply in the U.S. If you are doing consular processing, you're going to have to process abroad. Now, this is very highly impacted because of the country ban. The 75 countries that were banned there is a pause on all immigrant visa processing. So if you have a spouse, child, parent that you're trying to bring into the U.S. through consular processing, just expect massive backlogs and delays for this year. We're hoping that will change at some point in time, but we do not know when. So another question is, should you adjust your status now? So that is a case by case decision that you would make in conjunction with your immigration attorney. But here are some general pointers. Like if you've made a lawful entry into the United States, you have a priority date that is current or closed. That's closed for you being adjusting to adjust, then you should go ahead and adjust, right? As long as all your eligibility is there, but double check. Or if you need to have work authorization, or you want to lock in what you can now before anything else changes. So those are some of the reasons why people would want to adjust now. But I highly, highly recommend that you discuss your particular situation with an immigration attorney. I see in my office that the consultations we're doing now regarding adjustment of status and everything else are just so much more detailed, because what immigration is asking for us to prove as far as eligibility goes has expanded in the things that they're looking for. So I highly recommend, getting some advice before you make the decisions. Again, that is even if you made a legal entry, but you absolutely must speak with an immigration attorney. If you entered without inspection, you have significant unlawful presence, or you have some sort of criminal history, you had a prior removal or some sort of misrepresentation on your visa application that you might have, checked off inadvertently when you were applying for a visa to come into the US, or you're from one of the countries affected by the travel ban or any of the visa pauses. Now, specific issues that are AAPI related, along with H-1B, big impact in our communities. So I wanted to get into that a little bit. So we're hearing a lot of stuff about massive layoffs in the tech industry. We're seeing that on the ground here. So what happens if you're an H-1B visa holder and you've been laid off? Now, it has been kind of rule of thumb and in practice, that the 60-day grace period was just something that you get. We would always tell our clients, oh, you got laid off, don't worry, you have a 60-day grace period. This administration has made it very clear to us it is discretionary. It has always been discretionary, but we all used it. We never gave a second thought about it, but now we do have to think about it because it is discretionary, and we have to prove to the government why they should give it to us. Some of the options, if you find yourself in this situation, is to really try to find a new employer, change your status, or leave the United States, which, that last one is quite hard to do if you've been here on a H-1B visa for quite a while. You have kids in the school system, you have a home, cars, a whole life. One thing to remember is if you do lose your H-1B status, your spouse or your dependents lose their H-4 and their EAD status at the same time. Even if your EAD says it goes till 2028, it is no longer valid. In this particular environment, if you are laid off, you really do need to treat it as an immigration emergency. And one of the things I would say that is not on this slide is if you are laid off, please ask your employer to not submit an H-1B withdrawal letter with USCIS. What we're seeing on the ground is that it's triggering what's called an NTA, notice to appear in removal proceedings. You want to avoid that at all costs. Okay, so this is why I say it's very important if you are on an H-1B visa and you've had a layoff to treat it as an emergency, because there's a lot of things swirling around that. Updates to the program, it's been completely revamped. The lottery is still happening, but it's got a different way that they're approaching it. It is now moved to a wage-based selection. It's weighted on whether you have a U.S. master's, what your level of education is, bachelor's, master's, and also what wage level your American employer is willing to pay you. So There's also supplemental fees for H-1B dependent employers, and there's massive consular backlog. So anyone who is seeking to travel on an H-1B that does not have a valid visa, you really need to put some things into place prior to you going. So get some advice before you leave. I-140, you know what, we can address this later because I feel like we're running out of time, so I'm going to skip over this one. If there's anyone who wants me to deal with this, I can address it after. Denaturalization, big thing on people's minds. I get calls all day long. I'm so worried I'm going to be denaturalized. So what is it? It's when this administration will try to revoke your U.S. citizenship if you are a naturalized citizen. It doesn't apply to people who were born here, but if you're a naturalized citizen, there could be reasons that they might want to denaturalize you. And, you know, the current administration's policy right now, or what they're saying, is that if we believe your citizenship was illegally procured or obtained by fraud, however, there's a high standard that they would have to prove by clear, convincing, and unequivocal evidence that you illegally procured the citizenship or you obtained it by fraud. So historically, there were only 11 cases per year from 1990 to 2017. 11 cases per year. Under this administration, their goal is to do up to 2,400 of these cases a year. Now, don't panic. It still affects less than 1% of the 26 million naturalized citizens, but it's hard not to wonder, are they going to come after me? Right? So who's at risk? If you concealed serious criminal history or you had human rights violations, you used false identities or failed to disclose on your citizenship application a prior removal order, there was some sort of marriage fraud or some major immigration fraud. Honest applicants remain unlikely targets, but we know how that goes. So let's hope. So how do you protect yourself, right? You make sure you have a copy of all your past applications. If you have them with an attorney, get copies of them, right? Attorneys are required to keep copies of everything that was filed through their offices for at least 7 years. So make sure you have copies of everything that's ever been filed. If you do not, or it's past that 7-year mark, you can obtain records doing a FOIA request, Freedom of Information Act request, to USCIS, who will give you a copy of your whole record. If you are contacted by USCIS or Department of Justice, talk to an attorney before answering. And do not try to fix past errors on your own. I have seen that way too many times, and people just, create a mess, which could be sometimes hard to undo. Make sure you continue to do what you're doing, filing your taxes, maintaining good conduct, all of that stuff, because that will help you in case you are, a target of this denaturalization policy or enforcement. There have been a lot of scams targeting AAPI. There are notarios and consultant scams have surged. So people are being targeted on their social media, Facebook, Instagram, whatever, a fake attorney saying, hey, we can solve your problems. Please, anything coming through social media, you can always double check to make sure that they're legit before you give them your business. There's only 2 types of people who can give you legal advice, which is someone who's a BIA, which is Board of Immigration Appeals, who's an accredited rep through them, or a licensed attorney. And you can vet attorneys through the state bar websites to make sure that they're legit. And that they, don't have disciplinary actions against them, all of that stuff. So always double check. I wanted to just touch on this briefly, employer considerations. If you are an employer, you have to make sure that your employee completes what's an I-9 form. It is very, very important. If there's E-Verify that your company uses, make sure that they use it. If you are an employer that has H-1B, Visa holders, make sure you're giving them the proper wage, make sure your LCA is in compliance, and you cannot bench them. What that means is if there's no project for them, you can't put them on hold and say, we're not going to pay you until a new project comes in. They have to, you can't bench them and then not pay them. So the way to shield yourself against all enforcement on this particular issue, whether you're doing the right thing, is make sure you comply with all the rules and regulations around it. A seasoned immigration attorney that deals with H1s and employment immigration can help you with all of this. Now, what to do if ICE comes to your workplace? All employers should have a designated point of contact. They should involve an immigration attorney immediately. And remember that even administrative warrants in a workplace do not authorize entry to non public areas. So, ICE might be able to come in with their administrative warrant into your common space, but they cannot go into private offices, back rooms of restaurants or whatever. Where public is not allowed to go, they're not allowed to go. However, if they do have a judicial warrant signed by a judge, it may authorize searches. You are allowed to read it thoroughly before you give them any sort of entry into non public spaces. Workers still retain their rights. They can, they retain their right to be silent, to have an attorney, and they can refuse to sign any documents that ICE may present to them. Action steps and resources. So, what I recommend is to, if you are a vulnerable family, someone who could be targeted by ICE, create a family safety plan. What's going to happen to the children if mom or dad gets picked up? List emergency contacts, childcare backups. Have a list of where your bank accounts are, who your employers are, their telephone numbers, so people can be notified. Document where important papers are stored. Keep all of your immigration paperwork and receipts in one place. I would also go so far as to say organize it if you can, because it just makes it easier for whoever is trying to help, easier access. And make a digital backup of all your documents. Don't just keep them on paper. So those are, some of the things that you can do now to plan in case something were to happen. Make sure you stay informed. Rely only on official sources, right? USCIS, State Department, seminars like this, reputable organizations like AAPI, ACLU. Reach out to your community organizations, and this is one of the biggest things I see that I have to challenge in my practice of people calling us. Social media, we all know about misinformation and fake information. There's so much that's spreading that might not necessarily be true. Verify before you just believe, and act in a way that could be harmful to you. So a few key takeaways: know your rights, carry appropriate documentation, avoid triggering bars by leaving the country without proper legal strategy in place. Your employers and community do play critical protection roles, so we need to think about that as employers and as members of the community. And you're not alone. There are tools and resources that are available. So if you guys want to do, I'm not sure. Let me stop sharing my screen so I can see if there are any questions that need to be answered. Okay, I don't. Jeff, do you see? I don't see any questions
Yeah,
on
so we have
screen.
quite a few questions. I'll start off with the first one.
Okay.
This person asked, when I file my citizenship,
Yeah.
but change my state of residence for temporary reasons, because they're going to school, can I still continue with the process of my permanent residence being New Jersey, to go f for their biometrics?
For biometrics, yes. I mean, see, this is a very gray area. because I would need more. When you say temporary, but you're going to school, but if you're going to be there for 4 months, it can go either way, right? So the rule is you have to be a resident in the state that you're applying for citizenship through for at least 90 days. And you should be physically a resident of the state in which you apply. Now, can there be exceptions to the rule because you're a student and you're going to a different state for temporary reasons to study? Yes. Would I try to push it at this particular with this administration? I probably would not, because I would not risk being denied naturalization because I'm not a resident. So, what I would suggest in a situation like this is yes, go for your fingerprints if you're in the state of New Jersey, but then let the government know your address has changed and this is where you're living, and then let them make their decision whether they're going to move your citizenship case to the state in which you're going to school, right? Because then you can say, I've done everything that I possibly could. I let you know that I have this address.
Great. And I think we have a similar question about a family of four they're all applying for citizenship in March, but one member of the family has to leave the state in July, so a couple months later. Can the whole family apply together as New Jersey being the permanent address?
Sure, they can, but will the person who's leaving be interviewed in New Jersey if they have relocated somewhere else? Not with the risk of having that person's citizenship be denied. It won't impact the rest of the family if they still continue to reside in New Jersey, but if one member leaves after the filing of the application, they have to update their status. As legal permanent residents, they are required to not only carry their card, but also notify the government if they move. So if they move, they would update their status with immigration, and then immigration would automatically move their citizenship interview to their new location.
Great. Moving on to travel. How many days can a person with a green card stay abroad? Is permission required if it's more than 6 months?
So there is no way for the government to give you permission unless you're applying for what's called a re-entry permit. And a re-entry permit is something where the government does give you permission to be outside of the country for 2 years, up to 2 years. So you can do that if you know that you're going to be out for more than 6 months. Then I would suggest apply for the re-entry permit. And the rules around that are when you apply for the re-entry permit, you have to be in the United States and you have to go for fingerprints, and only after that can you leave. So you have to do it while you're here. You can't do it when you're abroad. I get questions like, oh, I went out for 5 months, but now my parent is sick and I won't be able to make it back in. What's going to happen? You can't apply for a re-entry permit at that point. You have to do it while you're here. So yes, you can do it, but to go back to the initial question, you should not at this particular point in time or ever, but it was a little bit more relaxed. I think there was more humanity at the border. Now that no longer exists, or very rarely, right? You should not be out for more than 6 months. And what I am personally telling my clients is you should not be out for more than 5 months. I do not want you to be questioned in detailed and overreaching questions about your life here in the United States. So if you come in within a 5 month period, it's a little bit easier to say, hey, look, it's not close. I have people who are saying, can I come in 2 days before it gets to the 6 months? Like, if you can help it, no, come in 10 days, 15 days before, 30 days, right? But sometimes situations, but 6 months, no more than 6 months without a re-entry permit, should you be outside of the US.
So we have a question about IDs, a couple of questions actually. So New Jersey has has introduced real IDs, right? Do real IDs count as proof of citizenship?
It should, right? Because I believe only citizens are allowed to get real IDs. But I'm not sure, right? I don't know 100% on that. I mean, it allows you to travel within the US, but I don't necessarily believe it's proof of US citizenship.
Okay. So the best form probably would be a
A
passport, right?
passport
You have a
card.
passport.
Yeah.
Okay,
Yeah.
great.
Because I think the real idea is just to allow you to domestically travel without having, not just using your driver's license. I think they were trying to create a federal system around it, but I don't think it's proof of citizenship.
Um, all right. I know that there's a lot of questions for international students right now. So for international students, either an F1 or a J1 visa holder, um, after they complete their program, is there any grace period before they receive their H-1B status or OPT status?
Well, that's a very multi-layered question because there's so many things that go into it. There's a 30-day grace period. When you finish your student status, um, you have to depart. However, there is, depending on if you are a student, there is always a bridge between when your student status ended and when your H-1B visa starts, right? But there are so many in betweens. I mean, like my mind is going crazy. Like it could be this, it could be this. So if it's something specific to you, I would say call my office and we can discuss it. Um, but as a general rule, 30-day grace period after your status is completed. But hopefully you've put something into place where you've switched to OPT or you have an H-1B approved and we can somehow bridge your status. There are alternatives and options for doing that in case there's a gap.
And I guess it never hurts, right? The message is like it never hurts to do that longer term planning, right? If you know you're
Absolutely.
graduating from your program, maybe start thinking about it, 6 months to a year or even more before,
Correct.
right?
Great point, Jeff. Because, yeah, I mean, we do get a lot of people who are, it's about to be done. What can you do? And it's like, well, if we only had more time. So, yeah, very good
And
point.
there's probably more solutions, or an attorney can probably work with you. It's easier to work with someone when they have more time to help you, right? Rather than
Absolutely.
like you're about to graduate and. Okay. So we have a couple of questions related to ICE. And I think that's going to be it for the amount of time that we have. But I think we answered almost all the questions. Um, so there's been a lot of reports about this memo that was circulated that says ICE agents do not need a judicial warrant to enter homes. Um, is there any guidance or information that you would provide folks about sort of, what they should do if ICE sort of enters their home or business without a warrant?
Document, document, document. That's all you can do in the moment, right? Because we know speaking up to them could cause us some, physical harm in some respects. So I think it's a document. It's documenting, right, and then bringing it up through the court system as to why this was a violation. It's not a good answer, Jeff, but sometimes the force of the folks that are there, the ICE agents, the amount, how they're doing it. Are they coming in helicopters? And there's, people, you can't really think. You get shocked. So it's really hard to have general advice for that particular point in time. What I say is keep it as nonviolent and as nice as possible. Provide IDs, and use your voice to say, hey, listen, you do not legally have the right to be here on an administrative warrant, judicial warrant only. We know our rights, but they are going to do what they're going to do, as we have seen, right? So then just document.
We have another question involving ICE in public areas, right? Like train stations, bus stations, parks, public places, right? Um, what does ICE have the ability to arrest people in these public places on the street, around a train station, at a train station, for example, without a warrant?
They do. Yeah,
Okay.
they do.
Um, and finally, this is an interesting question. This person asks, does the fact that we are within the border radius grant, I guess the border to Canada, CBP or ICE any additional authority?
Additional authority versus what they already have. I mean, they can arrest, they can detain, they can question, all within that 100-mile border range, which is, like I said, all throughout New Jersey. We're 100 miles, all of New Jersey.
I'm wondering if this person's also getting to, is it possible that there could be, more potentially more CBP presence here in New Jersey, or it might because of we're closer to the border?
I haven't seen an increase in the number of CBP officers on the ground at airports and stuff. Is it a possibility, right? It's like it's whenever the administration decides there's going to be a surge here, and then you're going to get however many folks coming in, right? What they've allocated, but I don't think by just because we are, um, all of New Jersey, I don't think we have an increased amount of CBP officers for just because of that.
Got it. So I think we've answered all of our questions. We really want to thank everyone for being here, and as RuPaul mentioned, sort of serving as those messengers, ambassadors to your families and your community members, and letting them know that there is information out there, and there is trustworthy information. Before we end, RuPaul, do you want to say some last words or some advice for folks?
I just want to say, I'm so glad you guys are all here today because I know that sitting behind this desk, I can only do so much, right? And that you guys are going to have to go out and spread this information, and you're the people on the ground doing all this stuff. So I really appreciate the opportunity to speak to you about it. And anything else I can be of help with, I am available for these types of presentations, whether it's to a localized community or through a larger organization like this.
Thank you so much, RuPaul. Really want to thank you for your time.
Thank you.